Hello everyone, welcome to the China Business Legal Navigator. The topic for the discussion today is how to navigate trademark protection in China's manufacturing sector, the critical role of contracts under the first-to-file system. In the fast-paced world of global manufacturing, the protection of intellectual property, especially trademarks, is a critical concern for businesses. This is particularly true in China, a leading manufacturing hub operating under a unique first-to-file trademark system. The system, while streamlined, presents specific challenges for manufacturers, especially those based overseas. In this environment, well-crafted contracts emerge as an indispensable tool for safeguarding trademarks. China's first-to-file system implications for manufacturers. Under China's first-to-file system, the first entity to file a trademark application is granted the rights to that trademark. This approach differs markedly from jurisdictions where trademark rights are established through use. For manufacturers, especially those relying on Chinese production for global distribution, this system can lead to scenarios where their trademarks are registered by others before they enter the Chinese market, before the finished production in China. This practice is known as trademark squatting. The manufacturing dilemma in the first-to-file landscape. International manufacturers often discover too late that their trademarks have been registered by third parties in China. This situation can disrupt supply chains, lead to costly legal battles, and damage brand integrity. Proactive trademark protection through strategic contractual agreements is just not just advisable, but essential. Remember that both private persons and companies can protect trademarks, patents, etc. in China. You do not want to end up in a situation where your Chinese manufacturers themselves or two other middlemen protect your intellectual property while producing your products in China. Contractual strategies for trademark protection. Manufacturing and supply agreements. Manufacturing agreements with Chinese suppliers should include clauses that strictly define the use of trademarks. These agreements can ensure that the manufacturer retains control over their trademark and can limit the supplier's ability to register or use the trademark without explicit consent. Licensing agreements for production. Licensing agreements are particularly relevant when a manufacturer needs to authorize a Chinese factory to use its trademark during production. These agreements should clearly delineate the scope, duration, and specific conditions under which the trademark is to be used, providing legal clarity and control. Distribution and export agreements. Manufacturers must include trademark protection clauses in their distribution and export agreements. These clauses can stipulate how the trademark is to be used in the distribution network and provide mechanisms for enforcement against unauthorized use or infringement. Joint venture and collaboration agreements. In joint ventures or collaborations involving manufacturing, it is crucial that contracts explicitly address the ownership, use, and protection of trademarks. This includes outlining the terms under which trademarks are used and shared within the venture and establishing clear protocols for protection and enforcement. Legal and contractual considerations in the manufacturing context. Drafting effective contracts in China requires a deep understanding of both trademark and contract law. Manufacturers must ensure that their agreements are not only legally sound, but also compliant with local regulations in China. It's important to choose jurisdiction in China to enhance enforceability, as the court in China seldom follow judges from foreign courts because of differences in laws. It is also essential to use a legally verified Chinese version of your contract to avoid imprecise translations from English and lower enforceability in the court in China, as contracts in other languages are translated into Chinese in the court in China. In the manufacturing sector, the significance of contracts in protecting trademarks under China's first-to-file system cannot be overstated. These agreements provide a necessary shield in a landscape where the race to register can have significant implications for business operations and brand integrity. For manufacturers navigating the complexity of the Chinese market, a robust contractual strategy is indispensable. Success in this domain hinges on a thorough understanding of the legal environment and a strategic use of contracts to ensure that trademark rights are not just established, but also effectively enforced. Thank you for listening to the China Business Legal Navigator. Contact us if you need legal help in China, help with background investigation of Chinese companies, verification of Chinese companies, protection of intellectual property like patents and trademarks, drafting and verification of contracts to the law in China, so they are enforceable in China, legal translations of contract, etc. If you require our assistance or have further questions about our services, please do not hesitate to contact our customer relationship manager, Jan Erik Christensen, at janerik@ncbhub.com. janerik@ncbhub.com. You can also visit our website, ncbhub.com. ncbhub.com. We look forward to hearing from you and helping your business succeed and grow in China.